It's live? All right, thanks. Good evening, ladies and gentlemen, members of the public, staff, and council. Welcome to the Monday, October 17th Committee of Adjustment meeting. We'll call the meeting to order. Can I have a mover and a seconder? Moved by Deputy Mayor Jaworski and Councillor Lang. All those in favor of the motion? Motion is carried. Thank you. Approval of the agenda. Are there any additions, deletions, or amendments? Ms. Haley?
No, there's not.
All right, seeing none. All those in favor of approving the agenda as presented? Motion is carried. Thank you. Moving on to item 3, approval of the minutes of October 3rd. Are there any amendments or deletions? Seeing none, can I have a mover and a seconder? Moved by Councillor McDonnell, second by Councillor Luck. All those in favor of the motion? Motion is carried. Thank you. And item number 4, declaration of pecuniary interest. Seeing none, we'll move into new business. A2222, Mayor. Ms. Haley.
Thank you, Mr. Mayor. So I'll just get started in our meeting this evening. Before we get started, I do have to read required wording under the Ontario Planning Act. So this is a hearing under Section 44 of the Ontario Planning Act. Any person may attend this hearing and or make written or verbal representation either in support of or in opposition to the proposed minor variance. If a person or public body does not make oral or written submissions at this hearing before the minor variance is decided upon, the person or public body is not entitled to appeal the decision of the Committee of Adjustment to the Ontario Land Tribunal, also known as OLT. If a person or public body does not make oral submissions at a hearing or make written submissions to the Committee of Adjustment before the minor variance is decided upon, the person or public body may not be added as a party to the hearing of an appeal before the OLT unless, in the opinion of the tribunal, there are reasonable grounds to do so. So we have one item on the agenda this evening, committee members. This property is located at part of Lot 7, Concession 9, in the geographic township of Lancaster, now in South Glengarry, and it's located at 21967 Concession 9, North Lancaster. The subject property is approximately 1.36 acres in area. This is a map of the location of the subject property. So you can see the turquoise highlights the property boundary. You can see the existing dwelling and the detached garage. This is a view of the subject property from Concession 9. So it just gives you an idea of the location of the dwelling and the orientation of the detached residential garage. In 2014, the Mays applied for a building permit to construct a detached residential garage at 21967 Concession 9. A building permit was issued on November 4th, 2014, and a site plan was submitted on April 30th, 2015, and was accepted by the building department. At the time of the building permit application, the site plan provided by the applicant owner met the zoning standards, meaning that the applicant indicated that the garage that was proposed to be built in 2015 was meeting the minimum required setback at that time of 1.2 meters, and that was the information that was provided to the municipality. All required building inspections were completed and the building permit file was closed. So I'm just going to turn to my papers here, I just can't read that. Recently, a survey was completed on the subject property that revealed that the southeast corner of the detached residential garage is set back 0.79 meters or 2.6 feet from the east property line, and the retaining wall that surrounds the garage is located 0.71 meters or 2.3 feet onto the neighboring property. The retaining wall was constructed to accommodate the grade differential between the subject property and the neighboring property to the east. The subject property and the neighboring property are approximately each 1.36 acres in area. At the time of the construction of the garage, the neighboring property was vacant. So now I have a couple photos to show you. So this is a close-up photo of the existing garage. This would be the southeast corner, and you can see the retaining wall is constructed and comes around the back of the garage. So the purpose of the minor variance that's before the committee this evening is the owner constructed a detached residential garage and a retaining wall in 2015, which did not conform to the required setback of the zoning bylaw. The following relief from Part 3.1 subsection 4 and Part 3.45 subsection 10 of the zoning bylaw 3809 is requested. to reduce the interior side yard setback for an accessory structure known as the detached garage from 1.2 meters to 0.79 meters, and to reduce the retaining wall setback from 1 meter to 0 meters to the east property line. I know this might be hard to see from where you're sitting, but the municipality requires a survey when a zoning amendment is being, when a minor variance is being applied for, simply because we need to have an accurate measurement showing what the existing measurement is in comparison to the requirement of the bylaw. And in this particular drawing, you can see the orientation of the garage, and then you can see the retaining wall coming around the corner, and it reflects the measurements that I've already provided to you. So here's a couple more photos of the subject property. The first one being is a northeast view of the subject property. So standing on the driveway looking northeast, you can see the neighboring property to the east. And then the second one is a southeast side view of the subject property. So the property is designated rural district in the county official plan, and the application does conform to the general intent of the official plan. A detached residential garage is permitted to be constructed, and the property is zoned as state residential, and it does conform to the general intent of the zoning bylaw. This is a zoning map showing the location of the subject property being right here and being located in the estate residential zone, and that kind of forms part of the overall Lancaster Heights subdivision area. The applicant was circulated to all abutting property owners within 60 meters and applicable municipal staff. I've received one written email from the abutting property owner to the east. To summarize that email, the neighboring property owner has expressed concern regarding the location of the garage. They requested the garage and the drainage pipes to be removed from their property. The Planning and Building Department have reviewed this application. We've spent quite a bit of time on this application just to understand how the building permit was reviewed, why was it issued, making sure that there was no error that was made in 2014 at the time of the issuance of the permit, as well as during the inspections. And we also worked with the property owner to ensure that there could be a solution to the situation if the minor variance was applied for. So the Planning and Building Department do support the application. We are recommending it to be approved subject to a condition. And the purpose of the condition on this recommendation is to ensure that the property owner obtains a building permit on or before June 30th, 2023 to alter the retaining wall to reflect the minor variance. In order to, I'll just speak to the building permit process a little bit. So if the minor variance happens to be approved this evening, the property owners will be required to retain an engineer. An engineering firm had done the original design of the garage, and the firm would then look at creating solutions to remove the retaining wall and alter the footing and the slab on grade to ensure there's adequate frost protection, relocate the retaining wall to a zero setback, and then we request that application be applied for by June 30th, 2023. The reason for that time frame is it would allow the property owners to work with an engineering firm, get the design done, submitted, reviewed by the building department, and the permit to be issued. We've also been made aware of some grading and drainage issues. This is not a subject that is to be really discussed at our Committee of Adjustment meeting this evening, although I am bringing it up for a reason. The reason why it's not a main subject for our meeting is because we're looking at whether the variance needs to be approved or refused based on the 4 tests and meeting the intent of the bylaw. But in touching on the grading and drainage issues, that will become part of the building permit review process, and it can be addressed by our chief building official and be remedied. Although if the property owners wish to do so, make those changes in advance, a permit is not required. So that's my presentation, Mr. Chair, and if there's any questions, I'd be happy to answer them. We do have the applicants here before us at the table this evening, and then obviously there's members of the public in the audience. So thank you.
All right, thank you very much, Ms. Haley. Did the applicants want to add anything to that before we go on to questions? No? Okay. Are there any questions of the committee? Oh, yeah. Councillor Lang. Oh. It's on the left side, I believe, Martin. Or it's on the back? Right there, there you go. Yep.
There. Thank you, Mr. Chair, and through you. Ms. Haley, why 0? To me, 0 is too close. If you could have, like, I know minor variances, we're supposed to have more than that, but even if we went to 6 inches, if the neighbors or these people, anybody decided to build a fence, 0 is pretty hard. Post or bigger, you know, if you've got a post and you're half and half, like, to me, 6 inches or so would allow, you know, something to happen in between there.
Through you, Mr. Chair, I'll do my best to answer that. So as I mentioned, there was quite a bit of review done by our chief building official to determine if there was an ability to alter the retaining wall and still provide adequate frost protection to the slab. And so it could be possible that there might be sufficient space if we reduced it to 6 inches. But what my understanding is that when it's a slab on grade, there's frost protection that's required. And the reason for a 1.2 meter setback is because that's standard for 3 or 4 feet of space to be used to then provide the adequate insulation to that slab. And so in this particular case, that was captured both in terms of the distance that was used as well as because of the grade differentiation, then there would have been, you know, insulation and then the retaining wall. So we recommended that it be 0. That's what our chief building official also recommended, because then it would give, you know, that I think it was 2.3 feet space for them to physically do the work and alter that foundation. Now, if it's something that the committee wants to see, it not to be a 0 meter setback, and you want to request it to the 6 inches, that's something that we certainly can discuss, but that would be up to the committee.
Thank you, Ms. Haley. I understand where they're coming from, and I understand the dilemma that these people are in, but if I was the neighbor, I would want to at least have enough room there that I could, you know, construct a fence someday if I needed to, or this. So my personal thought is what I'd like to hear from other people, but at this point I'm thinking I'd like to see at least 6 inches.
Okay, no problem. Councillor Luck, then Councillor McDonell.
Thank you. Through you, Mr. Mayor. I'm not suggesting we go this route, but I'm just asking so that I have like the full picture on it. Is there any other means of kind of dealing with this issue in terms of like an encroachment like agreement, or I'm curious to know all the different solutions. Thank you.
Okay, through you, Mr. Chair. So from a bylaw perspective, if you were to construct a structure over the property line and hope to obtain a building permit, the building staff could not issue a building permit because you have to meet those minimums. So I realize this is now existing and we're looking for a remedy. An encroachment agreement would have to be something that would be completed between the two parties if there was an agreement between the two parties. But once we become aware of a structure that doesn't conform to our bylaw, then our building staff has to respond accordingly and issue an order to comply to the building code. So I really don't see that being a viable solution. Another solution would be a lot addition, and that really would avoid the encroachment. It would correct the encroachment. It would provide, you know, adequate space, as Councillor Lang has indicated that, you know, it doesn't really leave a lot of room. But then that's something that you need the neighboring property owner to be willing to do, to go through that severance, to do a lot addition for, you know, a few feet or 4 feet or whatever it may be. But that would probably be the ideal situation.
Thank you. Councillor McDonell.
Through you, Mr. Mayor, just wanted to go through part of it, I guess. And when I look at this application, to me, and when I did my drive-by and kind of went by the property and took a look around, to me it looks like either the contractor or a combination of our people and the contractor, you know, maybe screwed up here, because to me, the angle and the plans that we're looking at when you look at the plan, the angle is in one kind of general direction, but the garage is almost turned 25 degrees, and that's where we're getting this discrepancy, I think. Because we are over the property line, and to me, I agree with Councillor Lang, I'd want at least 6 inches of a separation between myself and them. But As of right now, I'd like to hear from there obviously seems to be some good attendance here. I'd like to hear from maybe the adjacent property owners if they're here as well. And yes, there is a civil way, I think, of doing it, but that's not before this committee, and it's not up to us to make that decision. But I think 6 inches is probably minimum to be able to run Big O to the drainage ditch to take care of the drainage issues that are there right now, because as you can see, the drainage pipes appear to be 8, 10 feet, 11 feet in spots where they're across the property line. To me, that's unacceptable.
Okay, thank you. And Deputy Mayor Jaworski?
Thank you. Through you, Mayor Warden. Yeah, my question is along the same veins with respect to this 0 to the property line. How does that 0 to the property line recommendation deal with issues of drainage, or does it deal with issues of drainage? Because it seems like it's not quite enough. And also, the process as it goes forward in terms of site plan, correct me if I'm wrong, like, are we going to also have like a drainage plan that comes with it as well? Or is it because it's in a rural that we don't normally do that? Or can that be a requirement of the process?
So through you, Mr. Chair, according to the review that's been completed, there are no drainage issues in terms of water flow, water ponding, water not being exposed, coming off the property properly. The drainage issues that have been revealed are a little bit different. It's not because of the retaining wall only in this one corner of the property. So if you had one section of that garage with a retaining wall in the corner, that's not creating a drainage issue or a concern. In terms of answering your question from a bylaw perspective, because they are not located within a hamlet or within a settlement area and they're over 1.36 acres, a grading and drainage plan is not required by an engineer for a rural lot or a rural estate lot. However, if and when the building permit is applied for, and because we're aware of now these drainage pipes extending from the subject property onto the neighboring property, that's something that has to be rectified, because as you know, that's not allowed. You cannot drain your property onto another property. They have to come up with a solution of draining the water elsewhere, and ideally to the roadside ditch, so it would come south to the ditch. Whether that drainage, how they direct it by the retaining wall, that'll all have to be reviewed. And that'll be reviewed by the building staff at that time when the application is applied for. So grading and drainage isn't something a committee of adjustment generally deals with. We just have to trust that it would be something that would be addressed through the building permit process.
But to the issue of having enough space for...
0 or 6 inches, it'll have to be looked at. I can't really answer to you right now if 0 is a problem in that location from a grading drainage perspective, or is 6 inches enough to solve the grading and drainage in that particular corner. You can't do a whole lot with 6 inches from a swale perspective, and I'm not even sure one is needed in that location, but maybe it can come off the garage to the west and then south to the road. Again, that'll have to be looked at, and I'm not an expert at that.
Okay. Are there any questions or comments from the public? Yeah, please come up to the podium, say your name and address.
My name is Christine Lacombe, and I'm living at 21975 Concession 9 North Lancaster. I'm here because we're like a little bit disappointed of what's going on with our neighbors. They did the survey. We know they're on our side, and the zero minor variance, it's not logical for us. If there's something that's happening or they want to tondre le gazon, cut the grass, thank you. They'll have to come on our side because they won't have any space. So at least we want enough space for them to be able to cut the grass. And we don't want them anymore on our side. I've got pictures that they came on our side because all the branches are down. And we know that they didn't follow their side because we've got a rope. And I know they're coming on our side. We don't want them on our side anymore. So if the garage is a little bit like further than zero variance. I think this will solve the problem with not having them coming on our side and having problem for the rest of the time we're being over there. Sorry, I'm a little bit nervous.
It's okay.
Y a-t-il quelque chose d'autre, si je dis? Okay, what's about of the, because I know I've received an email from you and from Stephanie. What about the insurance title come into that? Because I had the answer that we maybe have to ask for the insurance title. We already have that. Is this something that if they're having problem with that they can pay a certain amount to do something with that, or?
So that would be a question for your lawyer.
Why am I supposed to take a lawyer when it's not my?
Because the lawyer, that's where you would have purchased the title insurance, whenever you purchased the property.
I had one.
Yeah, so the lawyer's the contact to get a hold of the title insurance company.
And what they will be able to do with that?
That would be up to the title insurance company.
So we're playing ping pong. I mean, why should I pay a lawyer for that?
I don't
When-
think your lawyer would charge you to get the title insurance number, to call them and speak. You've already paid for the premium of the title insurance.
Yes.
So if you called your lawyer and said, we're having an issue with our neighbor, could you please get me the information from the title insurance company? I can't see a lawyer charging you for that information. And then it would be best to speak to your title insurance company to see if there's any avenues for you to go about.
Okay, I understand. I
Yeah,
didn't know what's
that's
the
okay.
purpose
Yeah.
of the insurance title that I
Yes.
bought when I bought the
Yeah.
the land. Okay, but like I said, there's zero variance for us. We don't want that. It won't be like, it's illogical, it's not logical to have that zero line. If we want, like I said, with the grass, we want to put a fence, that means there's no way to play. It's either not on our side or not on their side. It's really in the middle of that. I mean, for me, I'm not taking it. It's on yours.
Okay, thank you very much, Messi, for your comments. Okay, is there any other comments or questions from members of the public? Okay, Ms. Haley?
Mr. Chair, just a comment regarding the fencing. I think most people are aware that you can install your fence on the property line. And we have a policy that regulates the height of the fence, the location of the fence. And if you install it on the property line, then the good side of the fence is towards the neighbor. But when you have a larger property like yours, and when I'm saying larger, meaning, you're not in the village of Lancaster, let's say, on a very small lot, we often recommend that you don't construct your fence on your property line. You construct your fence, several inches inside your property line, or maybe even inside a little further, so that you have adequate space to maintain that fence. And so nobody's going to force you to install it on the property line. I realize that's your choice, but you do have an option to place it on the inside of your line. So thank you.
Okay, all right, thank you for that, Ms. Haley. Are there any other questions or comment? Yes, sir? Yeah, just stand up, state your name and your address, and
Hi, my name is Marion Edo. I used to own the properties. The thing I'm wondering is, like, they knew that their garage was on the other side, but they still did it, and you guys missed it. So I don't find that's okay for the people that bought the middle lot of my property. They're stuck with the garage very close to their property. So I don't know. I don't think it's right. It's either, like, I don't know. There's laws that you're supposed to build so far, and you knew where the line was. So That's my point.
Thank you. Thank you. Councillor Martineau?
Yeah, through you, Mr. Mayor, I guess, Mr. Nadeau, I guess I kind of sympathize with him, because I mean, at the end of the day, I can appreciate that maybe a mistake was made, but I look at the drawing where it's supposed to be 5 feet, no need for a minor variance, and to me, somebody, between the contractor and ourselves, somebody missed it. It's, to me, we're about 6 feet off where it should be, 8 feet off where it should be. I don't know what the avenue is here. I don't know what the right answer is. I know I would want to see zero, or more than zero, sorry. I'd want to see some kind of separation distance as opposed to sitting right on the property line, but I struggle with this one just because you look at the plans, it's plain and clear. And we were made aware that, you know, it was going to be 5 feet, no need to worry about it, but somebody seriously missed it there. And maybe we've got to change our bylaws and we've got to start doing location surveys for buildings, you know, when they're within that close to the property line. But I mean, I just struggle with how we missed this. Whether it was us or the contractor, at the end of the day, it's a significant difference. It's about 7.5 feet.
Thanks, Sam.
Thank you, Mr. Chair, and through you. We're all responsible for what we do. I don't think it's the township's job to make sure that where the line is. If you're building something, you have to know where your property line is, especially if you know you're getting close. I mean, we have to own up to what we do. We all make mistakes. If you make a mistake, you have to fix it. So I'm willing to move forward with a minor variance, but I want at least 6 inches.
What's this? Yeah, I'll go to Stephanie and then I'll come back. Deputy Mayor Jaworski?
No, I agree with how Councillor Lang put that. But I do want to understand procedurally, how would that work if we want to make a requirement that is not the same as what you're recommending?
Okay. Ms. Haley?
Okay, so I'm going to answer that, oops. Do you want to go to?
Let Ms. Haley talk and then I'll go to the floor to you, sir.
So to answer that question, Deputy Mayor Jaworski, if you were to approve it at a 6-inch setback, what we would do is there would be a recommendation to reduce the required setback from 1 meter for the retaining wall to, I asked our clerk to convert 6 inches to meters for me so I know the exact setback. So 1 meter to 0.15 meters. And I would still recommend that you keep the conditions subject to the building permit being applied for and issued by June 30th of 2023. After that, I think I do have another suggestion for you, though, if you want to come back to me.
Okay. You had your hand up, sir?
Thank you. Couple of comments, if I may. I did have a chat with a couple of engineers, and in my conversation with them was basically what you discussed as far as the insulation and so on and so forth. And when I spoke with the engineer, I said to them, I said, the zero tolerance is sort of okay, but I would like it more. I don't know how that can be done, but it might be a possibility to reduce it as much. I don't know how much, but I'm supposed to have an engineer coming to take a look at the spot within the next couple of weeks, and by that time, I hope to have an answer as to we don't need zero, we can do it, let's say, using the 6 inches or the foot or whatever. And that's part of my plan. I always spoke with 2 engineers, but I'm waiting for a visit. And at this time of the year, you know, it's quite difficult to get anybody to come and visit or do things.
Okay, thank you. Ms. Haley answer, and then I'll go to you, Councillor Luck.
So one of my suggestions, Mr. Mayor, if the committee's thinking that 0 is not acceptable and that you're looking for some sort of setback, whether it's 6 inches or not, I would feel comfortable if you would defer it, and I'll explain to you why. What we could do is we could ask the Mays to have the engineering firm complete the design in advance of the decision being made. So if the engineering firm comes up with a design, and if it happens to be, you know, an 8-inch setback or a 10-inch setback, we have that design reviewed by our chief building official, make sure that it does comply to the code, it can work. Then we recirculate the application and come back to the committee with a specific number that we know is reflective of the design. So everybody has the right to apply, as you're aware. They have the right to apply for a number that they put forward. we talked to the Mays about that option, about having those discussions with the engineering firms to make sure it can be done. Our chief building official was confident there could be a solution. But that way then you will confidently know if 6 inches is sufficient. That would be an option.
Yep, Councillor Luck?
Thank you, through you, Mr. Mayor. I'm so glad that that came up, because I was just about to ask that if we could. Because I mean, like, I don't know how we can sit here, look at this application, and come up with a number based on absolutely nothing. So I'm all for deferring it and getting the answers that we need to. It sounds like the resident is willing and looking into options, and I'm in favor of deferring.
Okay. Deputy Mayor Jaworski? I'll go to you after her.
Yeah, no, thank you both for that, because that was going to be my next question, is how do we know what's the right, because I would like it to be moved back as far as it can be. You know, I don't think I'm in a situation where I would want them to tear down the garage, but I think we need to see just how far back we can push that retaining wall. And so we need more information. But how do we make sure within the process that we're not like leaving also the neighbors hanging? Like, how do we make sure that this keeps moving forward?
So through you, Mr. Chair, because we're aware of the construction now over the property line, even if we had the applicants not being cooperative, let's say they chose not to talk to us, they chose not to participate in anything or file any applications, under the Building Code Act and the Building Code, our chief building official has the right to issue an order to comply. So through the legislation we have, we can ensure that there's a remedy to the situation. So I'll walk you through the worst case scenario. Let's say we issue an order to comply and a date is provided and they don't comply with the date. Well, then we make them, we give them options. So there could be different options through the Building Code Act. At the end of the day, the garage could be told to come down as well. Like, so don't feel that there's not enough of a process outside of the zoning bylaw, outside of the Committee of Adjustment. It's something that our staff can address. However, we've had very cooperative property owners. I understand when they chose to retain the surveyor and they became aware of the setback of the garage being reduced, they became aware of the retaining wall going over the property line. They came to us right away with a letter from the surveyor. I then explained to them that I needed the survey, I needed the drawing to go part of the public process. So we've had cooperation all along. I would appreciate if we had continued cooperation with the Mays to continue to move forward. But I just want you to be confident that we have other steps and other legislative tools to ensure compliance.
Okay, Mr. May, yep, final comment.
Thank you. When I spoke with the engineer, he asked me if he could do that over the winter months because he was swamped. And I said, from the discussions we've had, we said that's something that's probably going to be done in the spring, and we both agreed to that. And then you mentioned that permit up to the 30th of June, so we sort of fall within that. And then I also spoke today with someone who could do this, call it landscaping job, and he said, well, definitely not this fall, but in the spring. So everything seems to be moving that way, and that's the timeline that I'm sort of looking at. It's not intentional. If I'd be younger and wouldn't have had the medical conditions I've had, I'd be doing it myself. But Mother Nature says no more work.
Okay,
Thank you.
thank you. Okay, Councillor McDonnell, and we got to wrap this up.
Yeah, just a brief comment, I guess, through you, Mr. Mayor, I guess at the end of the day, it seems as though the applicants are willing to work with the committee. They want to rectify this properly as well. I mean, the deadline we're setting, I think, is more than generous, and I would agree. I think it can be done over the winter months, and I have some faith in it because at the end of the day, currently your garage, eaves troughs, and parts are draining into the other property. So if things start taking too long, I guess the neighbor could realistically just cap them, and then you'd be in a little more trouble. So there's always something to work that way, but there's opportunities to work that way and try to get things moving quicker.
Final comments?
Yeah, if I may make a comment about the drainage. Spoke to the neighbor 2 weeks ago, the day we had our meeting for the application, and he mentioned to me that he was bringing some fill in. I said, that's fine. But he says, I'm going to be covering your pipe where it's draining. And then I said, that's fine. And then he said to me, but you have to cap them or move the direction of the flow, like over the wall. And anyway, yeah, because he said if the water goes in, he said then it's sort of going to freeze and destroy the wall or whatever. So my last visit to Cornwall, I bought some elbows that would fit the downpipe, whatever the heck it's called. And so to me, there's a solution, and I'd like to show it to him because he seems to know a heck of a lot more about this stuff than I do, so.
Okay, well, I think that's something you guys can work out amongst yourselves. So it's clear the committee wants to defer, so I need a mover and a seconder, and we're going to adjourn the meeting. So moved by Deputy Mayor Jaworski, second by Councillor McDonnell, that the motion is deferred. All those in favor of the motion,